Welcome to Law and Life, the Levoritz Approach.
Hello and welcome to Law and Life, the Levoritz Approach with experienced attorney Yoni Levoritz. I am your host, Kevin Rosenquist, and today we're going to discuss family law in New York. Yoni, thanks so much for being here.
Thank you for having me, Kevin. I appreciate it.
All right, so let's talk about the basics of child visitation rights in New York. How are they determined during divorce or separation proceedings?
How they are determined is basically a function of which court you're before. There are times when you can go before a court with the same basic facts and a different judge is going to rule a different way. Okay, it's a very tricky situation because the law only says it's based upon the best interest of the child. The best interest of the child is a very subjective test.
Yeah.
What is the best interest of a child? Especially when you're dealing with children 1, 2, 5, 7, 9, 10. You know, do you want the child who's going to have a stricter parent, a more lenient parent, more disciplinary parent, more liberal parent, more conservative parent? All of these things play into the issues. And therefore, I would say child custody litigation is probably the most complex part of what we do.
What else makes it that complex? I mean, I get why it is, but just out of curiosity, like what else makes it so complex?
Well, it depends upon numerous relationships. Relationship between mother and child, relationship between father and child, relationship between a possible third party and the child, which New York allows for, relationship between the judge and the lawyer and the other lawyer, and with the litigant. So you're dealing with so many different personalities and so many issues that it's truly the more compassionate side that typically rules at the end of the day. The person who can walk the high road, the person who's going to be able to withstand the onslaught of the characterizations that are being made and the character assassinations being made by the other side, and be able to say, listen, these things aren't necessarily true, or if they are true, they're being blown out of proportion, and explain their situation from a calm, cool, collected perspective.
What are some of the other common challenges parents face when negotiating child visitation arrangements?
Well, assuming both parents want the child, which is not always a given. I mean, many times you find parents who like the break of the every other weekend, who like the break of the week on, week off, or who like the break of what's called the 2-2-5 schedule. They like having children only on some days and not on others, and scheduling these things because it gives them freedom. So assuming in that situation, and you actually have a fully contested litigation, what you have to do is you have to basically mold the case to the wishes of the judge and possibly the attorney for the child or children.
How do you help navigate the complexities for your clients?
I watch all the players. I see what they're doing. I see what they're saying. I see if their complaints are valid or invalid. For example, leaving your kid in the car at the age of 4 while going into the dry cleaners with your engine running. That's a no-no. Judges are going to hop on that. If that's one of the complaints, you make sure your client never does it again. If they did do it. If they didn't do it, you deny it and you make sure it never happens. Okay? You have to be on offense with these things, and you have to also play defense with these things. So you're in a split situation where you have to basically take the high road in terms of, just by way of example, you know, a mother keeps launching allegations against the father. Father says, listen, these things aren't true, and here are my emails to back it up. Here are her text messages to back it up. You've got to put yourself in a situation where you're playing both offense and defense, and where you're also playing the court. The court has to be able to look at these things and say, you know what? Mom is histrionic, or dad is absolutely, off his rocker. And sometimes you have both. Sometimes you really have to choose between the lesser of two evils.
Yeah, that's a tough spot.
It's a tough spot for the judges too.
That's true. They're the ones that have to make the decision. So yeah, that's ugly.
Yeah.
So New York courts can issue different visitation orders, such as supervised or therapeutic. Can you discuss the circumstances under which each type might be appropriate?
Sure. Well, dealing with supervised or therapeutic, you're dealing with a situation where typically you have domestic violence, or you have children who do not want to visit their parents. So therefore, in a therapeutic situation, let's say you've got a 12-year-old child who doesn't want to see dad wants to see the child. The courts probably going to order therapeutic visitation to try and foster the relationship, to try and put it back together. Because at some point in time, they probably had a close relationship.
Right.
But that relationship deteriorated as a result of mudslinging, fighting in the house, domestic violence, and other issues such as that.
What are the key factors that courts consider when parents request a modification of an existing visitation order, and how can a parent best prepare for this process?
Modifications are tough because there's already a status quo in place. In a custody case, one of the factors that a court has to look at is how long the status quo has been in place. So if the litigation's going on for 4 years and dad has only seen them every other weekend, there's a decent chance or a significant chance that dad is going to continue with the same visitation schedule, maybe get a little bit more if he can show that mom lied about things or put him in a bad situation, which was unjustified. But even if she did, there's still a good chance that the father is going to be put in that position anyway of every other weekend. So when you have a modification situation and you have a status quo, the first thing you have to show is a change in circumstances. So what would that change in circumstances be? Mom gets a boyfriend, children hate the boyfriend. Children can't stand the boyfriend. They just want to do everything to get away from this guy. That may be deemed a change in circumstances that necessitates a change based upon what's in the best interest of the children or child. Another example, mom is just simply not with it. She's not sending the kids to school. She's not getting homework done. She's not getting doctor's appointments made. She's engaging in parental alienation. Change in circumstances. She's depriving phone calls. Change in circumstances. She's not doing what she was supposed to be doing.
Are there situations too where maybe one of the parents only gets every other weekend or gets less time because they were, either a screw up or had issues or whatever, and get their life sort of together and in hopes of seeing their kids more often?
Sure, you have that in drug cases. You have that in alcohol cases. Yes, absolutely. You have that even in prescription drug cases where people are abusing prescription drugs. I've had numerous cases where people had to be rehabilitated. And sometimes the trial process goes on so long that you can get them into AA meetings. You can get them into intensive outpatient programs with different hospitals. You can get them into different things to rehabilitate them before trial and then try and get them increased visitation over a period of time.
Okay.
But yes, those supervised and rehabilitative orders certainly apply in cases like that. They want parents who are going to be good and responsible and not put the children at risk. The last thing a judge wants is to have a child be abused or hurt or, God forbid, something worse, as a result of a misstep or a misdirection on their point.
Yeah, I could see that. How can grandparents in New York seek visitation rights, and what considerations do the courts make when coming to these decisions?
Again, it's very judge dependent. I've seen cases and I've litigated cases where judges basically allow grandparents standing and allow them to come in even though their child has not passed away, which is not what the law says. You have to also worry about courts applying the law in these situations. So you have to deal with that aspect of the case. But in general, grandparents should only be able to seek visitation if their child passed away, not because the parents don't want them seeing the children. Plus, they have to prove an existing relationship, which was deep and meaningful to a large extent and really played a role in the children's lives. So grandparent visitation is somewhat limited.
How does the mediation process for child visitation disputes differ from court intervention? And when might mediation be the preferred option?
Mediation is the preferred option when you have exposure. If you're the litigant who has a drug problem, an alcohol problem, a physical abuse problem, you want to try and mediate it to the point where you can reach an agreement that will allow you to come back without the showing of the change in circumstances. Now you have to worry about the fact that the other side, who has the leverage in terms of your misbehavior, is going to want to take this before the court. But if you can convince them to do a mediation and to come to an agreement and then have it presented to a judge, you can avoid airing your dirty laundry. And that's a very important thing to have happen in a case like that. Mm-hmm. Sometimes it pays to take less visitation time just to rehabilitate yourself. And sometimes also it pays to go ahead and have yourself supervised by a visitation expert or counselor, and rehabilitative visitation to show that what the wife is saying or the husband is saying is simply not true.
Does that mean that there's someone with you while you're hanging out with when you're spending time with your kid?
Yes, that is exactly what it is. That is what supervised visitation means. And that is what basically rehabilitative visitation means, as well as, other situations where you're trying to rehabilitate the relationship. There's going to be a social worker present for a good chunk of the time.
And how long does that typically, is there a general idea of how long that'll typically last before you can kind of earn you can show that you can be responsible and handle your children?
No, there is no specific amount of time. I've seen cases where it goes on for forever, basically. And I've seen cases where I've managed to get people out of it in a couple of months.
Okay.
They have 5-10 visits. They go through the process. The supervisor remains, somewhat neutral in the process. And they say, listen, dad seems to be a good dad to me. Mom seems to be a good mom. There's no reason for these visits to continue going on.
Okay.
And if you have a good report, a judge is likely to rely upon it.
What steps can a non-custodial parent take if their visitation rights are being obstructed? And how does your firm assist in enforcing these rights?
Prejudgment, meaning before there's an actual order, okay? We deal with them by asking for forensics, an attorney for the children, and by going ahead and documenting all the alienation. Diaries, emails, text messages, phone recordings, whatever we can get our hands on to show that the other parent is being obstructionist and obstreperous. Then what we do is we make a motion to the court and we say, Judge, look at everything they're doing. We need therapy for the child. We need co-joint therapy with my client. And at the same time, we need the court to put together a schedule where we can build on it, because the more time the child spends with my client, the less alienation is going to transpire. Therefore, what we have to do is we have to put ourselves in a position where the court is going to understand all of these different issues.
How do you approach creating custom visitation agreements that cater to the unique needs of each family, especially if it's contentious?
What we do is we go ahead and we develop the schedule based upon the actual facts in the case. Okay. Therefore, for example, if you're dealing with a highly contentious situation, you might want pickups and drop-offs at a police station. You might want pickups and drop-offs at the local McDonald's. You might want pickups and drop-offs at a neutral party's house. You might want witnesses present. Everything is custom made. We don't use templates in that sense. We use templates for minor little things like an adjournment. But when we're dealing with these situations, okay, we have to go ahead and deal with them on an individual basis.
Yeah, that's tough, man. A police station?
It's frowned upon. It's not something we like to do.
Right.
But if you're dealing with domestic violence situations, it may be the only way to do it.
Yeah. How does the court ensure that visitation arrangements are in the best child's interest? What are they looking at?
They're looking at basically what they get from the attorney from the child or children, and they're looking at what they're getting in terms of their feel for the case. People appear before the court, and they don't appear in a vacuum. Judges are used to reading people, and if they see someone as being obstreperous or someone as being difficult, then they'll go ahead and they'll deal with it. They'll go ahead and say, listen, we're not going to expand your access time. Okay, we're going to put you into supervised visitation. We're going to make you go to therapy as part of visitation.
What do you guys do? What does your firm do in advocating for the child's well-being?
We present the facts that are most suitable for the judge to come to the conclusion that we need him or her to come to. That's how we advocate. We advocate by putting our best foot forward and explaining everything from our perspective. Therefore, if you're dealing with someone who's an alcoholic, you're dealing with someone who has domestic violence issues, first thing we're going to come out of our mouths, or we're going to come out with the fact that, listen, there's been a finding of domestic violence. There's been a finding for an order of protection. This particular parent, he's obstreperous. He's been found guilty in criminal court. Whatever it may be, we're going to advocate for the client to make sure they get the best results and to make sure that at the same time, the court understands the person that they're dealing with.
What advice do you give parents entering into child visitation negotiations for the first time?
Be patient, listen, don't jump to conclusions. Let's take things one step at a time and breathe a lot, but breathe.
Breathe a lot. What other things should people keep in mind to protect their rights and their child's best interests?
Well, they should be keeping in mind the fact that they're looking for anything that the other person is doing what they perceive as being wrong. Therefore, the use of diaries, the use of cell phone memos, the use of calendars, husbands coming home from work every night at 1 o'clock in the morning. Should he have visitation on weeknights? I would say no. Okay. You should be keeping a log saying, listen, he came home at these hours, 5 days a week for, 6 weeks straight, and that's a good time to move on the custody and visitation end. They have to be proactive. They can't just rely on their lawyers. It's a team effort.
I have to believe that a lot of times people don't have all that information that would help their case. Is that true? Or do you find that in this day and age with cell phones and stuff that you're able to get a lot of evidence?
We're able to get a lot of evidence by doing a download of all people's text messages. People text message the craziest things, nasty things, things that shouldn't be said.
Right.
And when we dump them, we find a lot of good information. They typically don't have the calendars and the diaries, but it doesn't take long to build up a record. Therefore, we send them out and we say, start putting your ducks in a row while we start getting your ducks in a row, while we review your text messages, while we review your other information. Start keeping your logs and your diaries.
Do you find people are generally honest with you, or do you have to pull a lot of stuff out of them?
Depends on the client.
Mm-hmm.
It's very client dependent.
Yeah, I could see that. I could see a lot of people being like, "What? No, I didn't do anything." And then you're like, "Hey, come on, be honest with me."
Yeah, it happens.
I would say that's probably another piece of advice, huh? Like, just be honest with me.
Well, yes and no. Once they're honest with you, you're stuck with what they say.
Well,
okay. And not only that, when they're honest with you, you also have to question their perceptions. I've had people tell me that the parents are very good, but then the next thing I know, I've got a video of the mom or dad slapping the kid across the face. And I'm saying, this is good, and basically what happens is I have to confront the client and say, are you really okay with them doing it? Well, no, I'm not really okay with it. But, this is what happens. My daughter's a little bit out of control. My son's a little bit out of control. It's the best way to deal with it. You can't walk around slapping kids in the middle of a custody and visitation litigation. No, hands off.
Yeah.
Use timeouts, things that therapists are going to appreciate.
Timeouts. Yes. That's a common thing in my house. I'll say that right now with my little guy. So, well, thanks for tuning in to Law and Life, the Levoritz Approach with experienced attorney Yoni Levoritz. For more information or to connect with Yoni, you can visit levoritzlaw.com. And of course, be sure to hit that like and subscribe button and leave us a review in the comments. Yoni, great to see you again. Thanks for being here.
Thank you so much for having me.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.